Welcome to Lawyers Who Care, the video show podcast that highlights attorneys who go above and beyond for their clients. And on each episode, we'll meet a new lawyer and they will share stories of when they went beyond legal counsel for the benefit of their client. My name is Andrew Samelin. I'm the principal of Samelin Wealth, a nationally recognized wealth management firm for lawyers, their firms, and their clients. And let's applaud lawyers who care and learn from them. Today, my very special guest is Julie King of King Patent Law in Champaign, Illinois. And Julie is a licensed patent attorney who focuses her practice on intellectual property, business formation and transactions, and estate planning. Welcome, Julie.
Hi, Andrew. Thank you so much for having me on today.
Very welcome. So, Julie, when we were chatting a little bit in advance of this video, we talked about, one of the main practice areas, intellectual property. But before we go into that, tell us what brought you to the profession in the first place.
Well, I languished as an editor, having had an English degree for years, and I, wasn't really having much of an impact on the world, and figured if I was going to pay that much attention to detail, maybe I could be serving people better. So went to law school, and boy, I loved it. I loved law school, except for the exams, but it was great. And I was going to save the trees. So I didn't intend to be an intellectual property lawyer, but we all go into our plans with certain ideas and something else entirely happens.
That's it. So, you're paying attention to the details in the editing job, and now you're paying attention to the details with regard to intellectual property. How does that show itself when you come in every day?
Well, it shows up in that what my big background I also have a master's in computer science. So that level of detail, we're knowing, if a comma is going to throw something off when you should have put a semicolon, that translates really well into what I do as a lawyer, because in patent applications, honestly, that kind of grammatical mistake is a problem. But more importantly, it helps me really get into looking at all of the intellectual property that my clients have, not just maybe what they've come to me with, and helping them figure out a strategy for protecting all of that based on their goals, their budget, things like that. And it helps me make sure that those little details about all of that don't slip through the cracks.
So someone comes into your office and they say, I have an intellectual property question. What does that look like?
People often don't know their terminology when they come to me. Sometimes they do. Sometimes they've had a little bit of experience with an IP lawyer before, but most people really honestly don't know the difference between copyright, trademark, patent, or trade secrets. And they come to me and they say, well, I know I need something, but I'm not sure if it's a trademark or a patent. And they come to me to help them learn what that is, and then to help them accomplish their goals. And sometimes they know what they want the end result to be, but they don't have the slightest clue how to get there. And maybe patent's not in their budget right now, but trade secrets protection is, and we can talk about how to do that and also preserve patent rights for maybe when patents are in their budget.
And so they come in, they're stressed out. How do you manage that?
So one thing I do is, and you can kind of tell this today, I am not a suit and tie kind of lawyer. I am a rock and roll horror movie loving lawyer, and I like to, I don't hide that, and I don't hide that I'm kind of a big personality when I work with my clients. And I think the word that I keep getting from people is approachable and friendly, and you're not going to make me feel stupid by talking down to me and using legal jargon. And that's absolutely how I want them to feel. I want them to feel like they are part of the solution that we're working toward, and I'm not just doing things behind the scenes and going, trust me. I don't think that serves clients well. I think clients need to feel, they don't need to know the minute details of what we're doing, but if they feel like they understand what we're doing and why, then that takes all of that worry off of their plate. And that's really my job, is you go do what you're great at. Let me take this and do this for you and make you feel confident about it while it's going on. Because what I do, trademarks take usually a year, maybe more, to get that from start to finish. Patents are multi-year things. So we're talking about a long haul where clients are going to be nervous about what's going on, what's not going on, what's the next step, can I do this while we're waiting, those kinds of things. So my job is to take that level of anxiety way down.
Mm. Any horror stories for folks that have these incredible ideas and then they get,
Yes.
someone else kind of hops
The
in?
one I run into the most, and this is usually in response to blog posts on LinkedIn or something like that, is people don't know that there's a 12-month window between disclosing your invention to the public and being able to file to get patent protection. And I have had people come to me at basically 11 months and 3 weeks freaking out because they just found out about that. Or they've come to me and it's too late. And that is horrific, because that really does limit their ability to profit from that invention. And it's something that, that's not taught in business schools. That kind of level of detail about IP. They might teach what a patent is, but they don't tell you, oh, by the way, if you go to a trade show and talk about it, then you only have 12 months to file for a patent.
Got it. So
And
that means it's fair game?
Yeah, sadly it is. It's really unfortunate. And there are a lot of things in IP that you can kind of wiggle around, and that is not one of them. They would have to, at that point, make a new and improved version and then seek a patent for that. Yeah, it's awful. But I guess the thought is, if you're not willing to invest in it after you've made it public,
right,
for a year, you've got a year to do it, then maybe somebody else should come along and make that a viable product or service.
Right. Well, Julie, before we wrap up, if you could leave our listeners with one takeaway, what would that be?
I think it's the thing I like to tell every business owner is every business owner has intellectual property. Now, what that is going to vary from business owner to business owner, but you absolutely have copyrighted material, you have trademarks, and you might have trade secrets. Most likely you do. Some of you will have things that can be patented, but every single business owner has intellectual property. And my mission is to educate everybody about what that is and how to protect it.
Right. I'd like to thank my guest, Julie King of King Patent Law. Julie, can you provide our audience with your contact information, please?
Sure. The best way to get all of it is just to go to kingpatentlaw.com, but it's also at 217-714-8558. And you can just email me straight at julie@kingpatentlaw.com. And I'm at King Patent Law on like every social media platform. It's kind of gross.
Perfect. By the way, how do you like that as a method of reaching out to folks?
I have fun with it. I'm not sure how successful it is, but it entertains me. So there's that. But I've actually gotten a few people to who found me on social media, and I'm starting to show up in ChatGPT searches just because of the amount of stuff I put out, I guess. So I guess it's working.
Nice. Good for you.
Yeah.
This has been the Lawyers Who Care video show podcast that highlights attorneys who go above and beyond for their clients. And if you're an attorney or know one who does go above and beyond, feel free to reach out to us, 914-666-6600. Julie, thanks so much for joining us today.
Thanks so much for having me, Andrew.